This time, I'd like to invite His Excellency Tomas HEIDAR, President of the International Tribunal for the Law of the Sea, to the stage. He is here with us today to deliver a keynote speech. So please welcome him with a big round of applause.
Vice Minister of Foreign Affairs, Kim Jina, Professor Park Byung-do, Excellencies, distinguished guests. It is an honor to welcome you to the 10th International Conference on the Law of the Sea, hosted by the Ministry of Foreign Affairs of the Republic of Korea and jointly organized by the Korean Society of International Law and the International Tribunal for the Law of the Sea. On behalf of the Tribunal, I wish to convey our sincere appreciation to the Ministry of Foreign Affairs and the Korean Society of International Law for their initiative in holding this event and for fostering it into an increasingly influential forum for exchanging insights and deepening our collective understanding of the United Nations Convention on the Law of the Sea. Over the past 10 years, the conference has grown in both scope and depth, reflecting its maturity and responsiveness to developments in the law of the sea and the involving realities of ocean governance. From its early focus on foundational and institutional questions, such as the implementation of the Convention and the role of its dispute settlement mechanism, the conference has broadened its engagement to encompass a wide range of timely and emerging issues, including climate change, marine biological diversity beyond national jurisdiction, and new technologies. Across this wide spectrum of inquiry, two enduring threats can be discerned. The central role of the Convention as the foundation of ocean governance and the continuing and steady contributions of the Tribunal in clarifying and giving practical effect to the legal principles and rules embodied therein. This 10th anniversary offers not only a moment for commemoration, but also an opportunity for reflection. Over the past decade, the landscape of ocean governance has grown more interconnected. It is therefore timely to consider how the United Nations and its specialized agencies, as well as relevant institutions established under the Convention, have matured together and contributed to an increasingly coherent network. In this regard, the conference theme, celebrating a decade of dialogue, the expanding role of UNCLOS and Law of the Sea institutions, and the accompanying program aptly capture this spirit of shared growth and collaboration. Excellencies, distinguished guests, in illustrating this spirit of progress and cooperation, the United Nations has continued to serve as a central platform for mobilizing political will and setting global priorities. Importantly, Sustainable Development Goal 14, Life Below Water, has provided a policy framework for the conservation and sustainable use of the ocean and marine resources. Supported by 3 UN ocean conferences that have fostered renewed commitment to collective action. The UN Decade of Ocean Science for Sustainable Development has further strengthened international cooperation by promoting the generation and sharing of scientific knowledge needed for informed decision-making. Equally noteworthy is Action 22 of the 2024 Pact for the Future, through which states reaffirmed their determination to address threats to marine security and safety in accordance with the Convention. A particularly significant milestone is the agreement under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, or the BBNJ agreement, adopted under the UN auspices. Having now met its ratification threshold, this third implementing agreement of the Convention is set to enter into force in January next year. In parallel, the UN specialized agencies have continued to advance initiatives that align with the objectives of the Convention and strengthen and promote collective efforts towards a more cooperative and responsive approach to ocean governance. I note, among others, the 2023 strategy on the reduction of greenhouse gas emissions from ships adopted by the International Maritime Organization, the IMO, the strategy on climate change 2022 to 2031 adopted by the Food and Agriculture Organization of the United Nations, the FAO, and the ongoing negotiations under the auspices of the United Nations Environmental Programme, UNEP, towards an international legally binding instrument on plastic pollution, including in the marine environment. Taken together, these efforts demonstrate the growing coherence of global ocean governance. Each initiative, whether normative or operational, is carried out within the legal framework established by the Convention, which continues to serve as the foundation for cooperation among institutions in addressing the complex and evolving challenges facing our oceans. Excellencies, distinguished guests, I would now like to turn to another vital aspect of the Convention, namely its dispute settlement mechanism, and in particular the contributions of the Tribunal over the past decade. This mechanism is central to upholding the rule of law at sea and ensuring that the Convention is applied consistently and remains responsive to contemporary challenges. Since 2015, 9 contentious cases and 1 request for an advisory opinion have been submitted to the Tribunal. Of the contentious cases, 5 concerned the merits, 3 involved requests for provisional measures under Article 290, Paragraph 5, and 1 related to prompt release. The Tribunal also delivered a judgment in a case that had been submitted prior to 2015. During the same period, 6 cases were brought before Annex 7 arbitral tribunals, 3 of which were subsequently transferred to the Tribunal. This development reflects the growing confidence that states parties place in the Tribunal and its role within the Convention's dispute settlement regime. The Tribunal's recent jurisprudence provides a clear illustration of its continuing authority and relevance. In the interest of time, I will briefly touch upon 2 cases. The first case, the dispute concerning delimitation of the maritime boundary between Mauritius and Maldives in the Indian Ocean, provided the Special Chamber of the Tribunal with a rare opportunity to elaborate on the delimitation of maritime boundaries between archipelagic states. The Special Chamber clarified several aspects of the legal regime governing such states, including the treatment of archipelagic baselines, drying reefs, and low tide elevations, as well as the question of delimitation of continental shelf beyond 200 miles. I will come back to some of these points later. The second case, the advisory opinion on the request for an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law, or COSIS, marks another milestone in the Tribunal's jurisprudence. It was the first time an international court or tribunal examined the obligations of states under the Convention in the context of climate change. The advisory opinion underscored several notable aspects of the Tribunal's contribution: its close engagement with science, drawing extensively on the reports of the Intergovernmental Panel on Climate Change, the IPCC, its reaffirmation of the Convention's continuing relevance in the face of climate change, including through the interpretation of the term pollution of the marine environment as encompassing anthropogenic greenhouse gas emissions, and the clarification of the relationship between Part 12 of the Convention and other relevant treaties, such as the Paris Agreement, emphasizing that these instruments must be applied in a manner that upholds rather than undermines the object and purpose of the Convention. Excellencies, ladies and gentlemen, this brings me to the next part of my address, which concerns the linkages between the Tribunal and other institutions that work in complementary ways to advance the effective implementation of the Convention. Given the time available, I will focus on the Tribunal's linkages with three other institutions, namely the International Seabed Authority, the ISA, and the Commission on the Limits of the Continental Shelf, the CLCS, both of which were also established under the Convention, and the International Court of Justice, the ICJ. My purpose is to highlight how these institutions have complemented one another in their functions in supporting the implementation of the Convention. Firstly, I wish to touch upon the interaction between the Tribunal and the ISA. The link between them has historical roots dated back to the very outset of the Third United Nations Conference on the Law of the Sea. The initial idea proposed at the conference was to establish a tribunal dealing with disputes relating to the deep seabed as an organ of the ISA. Later, it was decided to entrust the settlement of those disputes to a chamber on seabed disputes to be established within the tribunal. Since then, the Seabed Disputes Chamber has served as the principal institutional link between the tribunal and the ISA. The Convention assigns both contentious and advisory jurisdiction exclusively to the Chamber. Its contentious jurisdiction is set out in Article 187 of the Convention, under which the Chamber enjoys exclusive jurisdiction to adjudicate, among others, disputes between states parties concerning the interpretation or application of the Convention's regime for the deep seabed, disputes between parties to an ISA contract concerning the interpretation or application, as well as disputes between the ISA and a prospective contractor concerning the refusal or negotiation of a contract. While this part of the Chamber's jurisdiction has not been yet put into practice, it holds considerable potential that may be realized as activities relating to the exploration and exploitation of the resources of the deep seabed progress. As provided for in the current draft of the exploitation regulations under negotiations at the ISA, disputes concerning the interpretation or application of these regulations and an exploitation contract shall be settled in accordance with Section 5 of Part 11 of the Convention. The Chamber's advisory jurisdiction, on the other hand, has already been put into practice. In May 2010, the Council of the ISA submitted to the Chamber a request for an advisory opinion on the responsibilities and obligations of states, sponsoring persons, and entities with respect to activities in the area. This request was made pursuant to Article 191 of the Convention. The Chamber delivered the advisory opinion on 1 February 2011, offering several key clarifications that have shaped our understanding of how sponsorship operates in the deep seabed. Among its most crucial findings was the interpretation of the responsibility to ensure under Article 139 of the Convention. The Chamber explained that this is not an obligation to achieve a particular result, but one of due diligence, requiring sponsoring states to do the utmost to ensure that their sponsored contractors comply with the Convention, and also the 1994 implementing agreement and the terms of their contracts with the ISA. The Chamber emphasized that due diligence is a variable concept that may evolve with advances in science, technology, and understanding of the risks involved. Furthermore, the Chamber identified a second category of obligations, namely direct obligations. These obligations are binding on sponsoring states independently of the contractor's conduct. Among them are the obligation to assist the ISA in the exercise of its functions, the obligation to adopt and implement best environmental practices, the obligation to ensure access to recourse for compensation, and two obligations that the Chamber identified as potentially having or already possessing the status of customary international law, namely the obligation to apply the precautionary approach, and the obligation to conduct environmental impact assessments. The Chamber also made crucial findings about the issue of liability. There is not sufficient time today to delve into the details of this aspect. However, it may be helpful to note that the Chamber made clear that the liability of a sponsoring state does not arise from the conduct of the contractor, but rather from the state's own failure to fulfill its responsibilities. The advisory opinion, which was recognized by the Secretary General of the ISA and several members of the Council as a milestone in the life of both the authority and the law of the sea, had an immediate and substantive impact. At its 17th session in 2011, in light of the advisory opinion, the Legal and Technical Commission of the ISA recommended revising the regulations on prospecting and exploration for polymetallic nodules to strengthen environmental protection, enhance the application of the precautionary approach, and incorporate best environmental practices. In 2013, the Assembly of the ISA approved amendments to those regulations. The implications of the advisory opinion have been unabated afterwards, as demonstrated in the ISA's ongoing negotiation of the exploitation regulations, where the precautionary approach is proposed to be further strengthened and recognized as one of the guiding principles, approach, and policies of the instrument. In the advisory opinion, the Chamber stated that it will assist the organs of the authority in the performance of their activities and contribute to the implementation of the Convention's regime. As advances occur in both the regulatory framework and technological capacities, the Seabed Disputes Chamber is well prepared to make further contributions in this field whenever it is called upon to act by the ISA or other stakeholders. Secondly, I wish to turn to the linkages between the Tribunal and another body established under the Convention, namely the CLCS. According to Article 76, Paragraph 8 of the Convention, the mandate of the CLCS is to make recommendations to the coastal states on matters related to the establishment of the outer limits of the continental shelf. This process, often referred to as delineation, is different from the delimitation of an outer continental shelf. Under Article 83 of the Convention, the latter function is assigned to competent forums provided for in Part 15 of the Convention, including the Tribunal. As the Tribunal observed in its judgment in the dispute concerning delimitation of the maritime boundary between Bangladesh and Myanmar in the Bay of Bengal, the first ever instance in which an international court or tribunal delimited the continental shelf beyond 200 miles, the Convention sets up an institutional framework with a number of bodies to implement its provisions, including the CLCS, the ISA, and this tribunal. Activities of these bodies are complementary to each other so as to ensure coherent and efficient implementation of the Convention. This principle of complementarity has since shaped the Tribunal's approach to its relationship with other institutions under the Convention. In the Bangladesh-Myanmar case, both parties had made submissions to the CLCS, but the Commission had not been in a position to consider them in the absence of mutual consent by the parties. The Tribunal therefore faced the question of whether it should refrain from exercising jurisdiction until the CLCS had made its recommendations. After emphasizing that the function of the CLCS related to delineation is without prejudice to the delimitation function of international courts, and vice versa, the Tribunal stated that in the present case, it would have been hesitant to proceed with the delimitation of the area beyond 200 miles had it concluded that there was significant uncertainty as to the existence of a continental margin in the area in question. However, in this regard, the Tribunal noted that the Bay of Bengal presents a unique situation as acknowledged in the course of negotiations at the Third United Nations Conference on the Law of the Sea. Noting the uncontested scientific evidence regarding the unique nature of the Bay of Bengal and information submitted during the proceedings, the Tribunal decided to proceed with the delimitation. This reasoning laid the foundation for the Tribunal's subsequent jurisprudence in the Mauritius-Maldives case, which, as I implied earlier, represented the first delimitation case between two archipelagic states. In that case, the Special Chamber not only applied but also further clarified the significant uncertainty standard in Bangladesh, Myanmar. Specifically, the Special Chamber explained that the significant uncertainty standard serves to minimize the risk that the CLCS might later take a different position regarding entitlements in its recommendations from that taken by a court or tribunal in a judgment. Applying this standard, the Special Chamber found that it was not in a position to determine Mauritius' entitlement and thus did not proceed with delimitation beyond 200 nautical miles. It noted that the exercise of caution is called for in the circumstances of the present case, where there may be a risk of prejudice to the interests of the international community in the area and the common heritage principle. With its finding, the Chamber acknowledged the impasse arising from the fact that neither party had given consent for the CLCS to consider the other's submission. It encouraged both parties to contemplate giving such consent, demonstrating its awareness of the importance of effective coordination among the Convention's institutions. Building on this spirit of complementarity, I finally turn to the relationship between the Tribunal and the ICJ. Part 15 of the Convention sets out the relationship between these two judicial bodies. Either of the two institutions may be chosen by states parties as the forum for the settlement of disputes concerning the interpretation or application of the Convention. Obviously, the existence of multiple judicial bodies entails the risk of inconsistent jurisprudence or judicial fragmentation. While differences may occasionally arise, the jurisprudence of ICLS and the ICJ has generally reinforced one another, contributing to greater coherence and consistency in the law of the sea. This complementarity is reflected in the jurisprudence of both bodies. In the Bangladesh-Myanmar case, the Tribunal referred to the three-states approach established by the ICJ in the maritime delimitation in the Black Sea case, and subsequently followed this approach. In turn, the ICJ referred to the Bangladesh-Myanmar case in its later maritime delimitation cases, such as the maritime delimitation in the Indian Ocean, the Somalia-Kenya case. To illustrate this dynamic further, I will briefly discuss two recent examples. First, the Special Chamber's judgment on preliminary objections in the Mauritius-Maldives case, and second, the ICJ's advisory opinion of 23rd July last concerning the obligations of states in respect of climate change. Let us first look at the judgment on preliminary objections in the Mauritius-Maldives case, which demonstrates how the Special Chamber drew extensively on the ICJ's 2019 advisory opinion on the legal consequences of the separation of the Chagos archipelago from Mauritius in 1965. In its judgment, the Special Chamber noted that while it is generally recognized that advisory opinions of the ICJ are not legally binding, it is equally recognized that an advisory opinion entails an authoritative statement of international law on the questions with which it deals. The Special Chamber explained that such opinions carry no less weight and authority than those in judgments, as they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with competence in matters of international law. On that basis, the Special Chamber concluded that determinations made by the ICJ in an advisory opinion cannot be disregarded simply because the advisory opinion is not binding. The Chamber recognized those determinations and took them into consideration in assessing the legal status of the Chagos archipelago. Through this approach, to the legal effect of the ICJ's advisory opinion, the Special Chamber not only advanced the understanding of the advisory function itself, but also strengthened the harmony and coherence among international courts and tribunals. Turning now to the ICJ's advisory opinion on obligations of states in respect of climate change, we find a further example of how the jurisprudence has developed in a spirit of complementarity. When considering the questions submitted to it by the United Nations General Assembly, especially on those aspects related to the law of the sea, the ICJ was mindful of the jurisprudence of the Tribunal. In particular, as I touched upon earlier in my address, the Tribunal had rendered a landmark advisory opinion on 21st May 2024, in which it elaborated in detail on states parties' obligations to combat climate change under the Convention. In this regard, the ICJ made a notable general acknowledgement of the Tribunal's case law, stating that since its establishment, ICLS has developed a considerable body of jurisprudence on UNCLOS, both in contentious and advisory proceedings, and in so far as it is called upon to interpret the Convention, it should ascribe great weight to the interpretation adopted by the Tribunal. Following this approach, in the section of the advisory opinion devoted to the law of the sea, the ICJ referred to the interpretation adopted in the Tribunal's advisory opinion of 21st May last year on multiple occasions, including with regard to the question whether anthropogenic GHG emissions constitute pollution of the marine environment, as well as with regard to Articles 192, 193, 194, 197, and 206 of the Convention. Beyond this, the ICJ also referred to the jurisprudence of the Tribunal on matters such as the obligation of due diligence, risk of significant harm to the marine environment, the duty to cooperate, and the relationship between obligations arising from different sources of international law, thereby following the interpretation adopted by the Tribunal in its advisory opinion. Through these examples, the Tribunal and the ICJ have not only strengthened the coherence of the law of the sea, but also underscored the complementarity between their jurisprudence in interpreting and applying the Convention. Excellencies, distinguished guests, as we commemorate a decade of this forum, we celebrate not only its achievements, but also our shared dedication to the rule of law at sea, a principle that is ever more vital in today's complex geopolitical environment. As ocean challenges evolve, sustained institutional cooperation and continued legal clarification remain essential. The Tribunal will continue to play a key role in this regard, providing authoritative interpretation and guidance, including through advisory opinions. Looking ahead, the international community must together navigate pressing issues such as sea level rise, deep seabed mining, and emerging ocean technologies, ensuring that the law of the sea remains a resilient and unifying foundation for global ocean governance. The next decade will undoubtedly bring new challenges, yet the foundation of the rule of law at sea, firmly anchored in the Convention, remains strong and will continue to guide our collective efforts toward a peaceful, just, and sustainable future for the oceans. I thank you for your kind attention.
Thank you very much for your insightful